This presentation is an introduction to the guidelines on the information to be contained in Environmental Impact Assessment Reports, or EIARs. The EIAR is a report prepared by developers to accompany applications for consent. It's the main document used to inform the EIA process. The developer prepares the EIAR and the competent authority considers it as part of the decision-making process. The EPA's role in publishing these guidelines comes from Section 72 of the EPA Act. And the guidelines are a statutory document that should be regarded by developers, practitioners, and competent authorities. Developers are obliged to take account of these guidelines when preparing an EIAR, and similarly, the competent authority is obliged to have regard to them when considering the EIARs that are submitted to them. Even though the guidelines are published by the EPA, it's important to point out that they apply to all projects covered by the directive in the state, not just the regimes for which the EPA is a competent authority. And there are advice notes that are designed to accompany the guidelines. The advice notes don't have the same statutory footing as the guidelines, and the agency are not required to publish them. But current advice notes dated 2003 are on our website that were originally published to coincide with the 2002 guidelines, and these will be updated now later in the year, following the publication in May of the guidelines. The link at the bottom of the slide is just to the section of the EPA website where the guidelines are available to download. So that'll take you through to the publications section of the EPA website shown here in the slide. And it's the monitoring and assessment tab that you need to go to, and then within that, just the assessment section. And the guidelines will be available there as shown, and the little picture of them and the download button. And then underneath that, the advice notes on the current practice in preparation of environmental impact statements dated 2003 are linked, a link there directly to those advice notes. So the guidelines, to give some background to them, they were originally published in 2002, which is the first kind of image you'll see at the top of the screen. The guidelines and the information to be contained in environmental impact statements at the time, and they were subsequently revised then and in draft since August of 2017, which is the kind of middle cover page, and now the guidelines have been formally adopted and published, replacing all previous versions and taking into account the transposition of the amending EIA directive, as well as lessons learned and experience gained through EU and Irish case law. The revision of the guidelines was carried out by the consultancy CAS in close collaboration with a working group that was convened and chaired by the EPA and made up of government departments, institutes and agencies. And this group met at key stages throughout the process of the revision of the guidelines to discuss emerging issues, to offer comments and to give direction on the revision of the guidelines. Just to give a bit of a background on the kind of evolution of the EIA directive, the first EIA directive was published in 1985, and then following that it was amended 3 times, as you can see, and codified then as the 2011 directive. It was then further amended by Directive 2014/52/EU, and the 2014 directive amends and updates the previous directive. Both directives should be read together. One does not replace the other. So the kind of formal reference there is in red, and a consolidated version of the EIA directive is available to download on the Commission website, and is a very useful reference document. The amended EIA directive, the 2014 directive, is what brought in the use of the term EIAR, which for what was formerly referred to in the Irish legislation as an EIS, an environmental impact statement. So just to go through some of the key changes relating to information to be included in an EIAR that have come in with the 2014 directive, we can it requires nothing less than what was in the previous directive. There are some additional requirements or more specific requirements. In relation to competent expertise, a developer must ensure that an EIAR is prepared by competent experts. And recital 33 of the directive goes further to say that the experts involved, that's recital 30 of the directive, that the experts involved in the preparation of the EIAR should be qualified and competent. And the requirements apply also to competent authorities themselves, who must have or have access to the sufficient expertise to assess the EIARs that are submitted to them as part of the consent process. Then in relation to the other changes, EIARs are to be made more understandable for the public to allow for increased public participation, especially as regards assessments of the baseline and alternatives. It was always a requirement of an EIAR to ensure that, or of EIA, of the process of EIA to ensure that a proposed development is assessed by reference to alternatives. But the 2014 EIA directive clarifies that this requirement relates to the reasonable alternatives studied by the developer, which are relevant to the project and its specific characteristics, and an indication of the main reasons for the chosen option, taking into account the effects of the project on the environment. Other changes then that are related to the EIAR are to do with the factors that have changed slightly. Well, land is added, human beings is replaced by the previous population and human health. The previous term human beings is replaced by the new population and human health, and flora and fauna is replaced by biodiversity. Other additional information then for inclusion in the EIAR are descriptions, for example, of demolition works as part of a project where that's relevant, the use of natural resources during the construction and operation phase, impacts of the project on climate and the vulnerability of the project to climate change, protection of the marine environment, and effects deriving from the vulnerability of the project to risks of major accidents and disasters. So these are just some of the key changes specifically relating to information to be contained in EIAR that are dealt with in the guidelines. But there are other significant changes not relating specifically to the EIAR that came in with the 2014 directive, such as screening requirements, scoping requirements, and the definition of the EIA process is defined now in the new directive. The guidelines, the primary purpose or objective of the guidelines is to improve the quality of the EIARs, setting out what information needs to be contained in the EIAR and facilitating compliance with the directive. They are written primarily with a focus on the obligations of developers, but they will also be a valuable document to assist competent authorities when considering EIARs during the decision-making process, and just ensuring that they are compliant. They will be also a useful document for all parties to the EIA and an authoritative reference for those parties, including the public. For the purposes of the guidelines, the term developer is used to mean the applicant for authorization for a private project or the public authority, which is initiating a project. It's the person or the entity that is proposing to carry out a project. And then the project itself, that word is used to encompass all of the various forms of development, works and activities that are prompting the requirement for an EIAR. So those two terms are used throughout the guidelines. There is also a glossary at the back of the guidelines, which provides a description of many of the terms used throughout. And the guidelines advise on the general principles and methods only. The guidelines are organised into three main parts. As said previously, the primary purpose of the guidelines is to set out what information needs to be contained in an EIAR, But the first section there, section 1, the role of EIARs in the EIA process, gives an overview of the EIA process itself and where the EIAR sits within it. The second section then is the main section of the guidelines, which deals with the preparation of the EIAR itself and gives comprehensive information to the developer on the types of information to be included there. And then the last section, which is a much shorter section, is just a general section really dealing on the guidance, dealing with guidance on the presentation of information, just kind of general information on content, language, terms, illustrations, non-technical summaries, and all that type of thing, kind of the layout and presentation of the information. So the first section then, the role of EIARs in the EIA process. The figure on the left is taken from the guidelines themselves, and it shows the position of the EIAR as the principal document within the EIA process. So the EIA is the process which is defined in the 2014 directive, as we said, which anticipates and predicts the effects on the environment caused by a project and which informs the competent authority's decision-making process, whether to grant consent or not, and if granting, what conditions to include. And the EIAR, the main purpose of that document is to identify, describe, and present an assessment of the likely significant effects of the project on the environment for all of the stakeholders to be that is accessible to all the stakeholders and that the competent authority will use during their scrutiny and consent process. The EIAR isn't defined in the directive, but it is defined in the Planning and Development Act. And the definition is shown there on the screen. You may not be able to read it, but it says a report of the effects, if any, which proposed development, if carried out, would have on the environment and shall include the information specified in Annex 4 of the EIA directive. And so Article 5.1, which is the box on the right, I don't expect anyone to be able to read that from here, but that's just a screenshot of the guideline of one section of the guidelines where Article 5.1 is shown, and the accompanying Annex 4, which it relates to, which is in Appendix 2 of the guidelines. That article with the annex really they describe what an EIAR is to contain. So the guidelines are really kind of giving developers additional and competent authorities, additional information to alongside that article and annex to kind of guide what level of information, what types of information should be included. So the main section then of the EIAR of the guidelines is the section 2, which is the large part of the guidelines referring to the specific details on preparing the EIAR. And this figure again comes from the guidelines, and it shows the steps involved in the preparation of an EIAR in sequence. And the little yellow boxes on the left, they refer to the particular section of the guidelines where that topic is dealt with. So the top is screening. So that's whether the EIAR is actually required in the first place. If it is, then moving on to scoping, what should the EIAR cover? What types of information would be required? And then getting into the actual contents of the EIAR from section 3.4, consideration of alternatives, down to 3.8 there, mitigation and monitoring proposals, all of that information which makes up the EIAR itself are dealt with in those particular chapters. So in the consideration of alternatives section, the guidelines set out information on the presentation and consideration of the various reasonable alternatives investigated by the developer. The objective there really is to give a representative range of the practical alternatives considered by the developer. Then moving on to the project description, the developer is required there to provide a description of the whole proposed project, comprising information on the site, design, size, and other relevant features of the project within the EIAR. The range of information and the level of detail required here should be sufficient to fulfill the needs of the consent procedure that the EIAR is submitted for. And all relevant phases of the life of the project should be considered, for example, from construction through to existence or operation, and in some cases then also restoration and decommissioning. So guidance on all of that information is in the guidelines. And then after the description of the proposed project comes the description of the baseline scenario, which is the second of the two factual foundations of the EIAR, referring to the current state of the environmental characteristics. And comprehensive information is given in the guidelines from page 43 to assist developers in describing the baseline. And the next section then is assessment of effects, which is the key and main section, I suppose, of the EIAR to see what effect this project is going to have on the baseline environment, taking into account all of the environmental factors listed on the right-hand side, from population, human health down to landscape. Assessment of effects is going to be covered on the next slide, so I'll just move on then to the last section, which is just the mitigation and monitoring proposals by the developer to address adverse effects. And to bear in mind that the description of the likely significant effects on the environmental factors should cover the direct effects, obviously, but also any direct, secondary, cumulative, transboundary, short-term, medium-term, long-term, permanent and temporary, and positive and negative effects of the project. So in relation to the assessment of effects, the main purpose of an EIAR is to identify, describe and present an assessment of the likely significant effects of the project on the environment. The EIAR focuses on effects that are both likely and significant, and the description of effects that are accurate and credible. And the assessment of the effects needs to leave a clear documentary trail of the analysis used to arrive at conclusions. The description of effects can be subjected to close scrutiny, so clarity here of the method, language and meaning are vital to accurately explain the range of effects, and the guidelines promote the use of a systematic approach to standard descriptive methods and the use of replicable assessments, techniques and standardized effect descriptions to ensure that all of the likely significant effects are adequately considered and clearly communicated. So the guidelines go into quite a bit of detail on the assessment of effects there, and they also include tables. This is just one section of one of the tables starting on page 50, where it provides kind of standard description of effects that may be used by developers. Moving on to the third section then, this is the presenting of the information. So it's kind of more general guiding information on content and structure, language, terms and illustrations, including key editing considerations, using terms consistently, avoiding repetition, that type of thing. And it includes guidance on the non-technical summary, structure and contents. This is then followed by a section on the next steps in the EIA process, as we saw on the previous figure, the scrutiny and consent, and the mitigation and monitoring and enforcement parts of the EIA process. And then there's a glossary of terms, and of course, as I mentioned, the Annex 4 of the directive is copied in its entirety into Appendix 2 of the guidelines for ease of reference. So a review of case law was carried out during the revision of the guidelines, and relevant case law summaries are included in blue boxes throughout the guidelines, where relating to the appropriate section where they are. This is an example of two of the case law summaries, so they appear in these little blue boxes throughout the guidelines. On the left, there is so this on the left, this is case law box, relates to the level of detail in project description, and you've got the People Over Wind Borpanola case, which is back in 2015, and then updated summary relating to the Sweetman and Borpanola case of 2021 there. And then on the right, there's within the kind of cumulative assessment of cumulative effects section of the guidelines, this Apple Data Centre case law summary is shown in the guidelines. So they're just screenshots from the guidelines themselves. Knowledge, understanding, and the application of all aspects of EIA are subject to emerging case law in the national and European courts. And the case law reflected in these guidelines is not exhaustive, and subsequent case law and legislation obviously should be considered. A comprehensive list of the relevant case law and the legislation as well was not provided in the guidelines, as it was thought that it would become quickly outdated. So that's everything from me. Thank you very much for listening, and we will now address any questions anybody has and any questions that were submitted. Thank you.